Proposed amendments to laws governing the electoral system will give the Independent Electoral Commission the power to change the way we vote in elections. The Electoral Law Amendment Bill is being debated by the Portfolio Committee on Home Affairs. Civil society and the public are concerned that clauses 14 and 21 give too much power to the IEC. Joining us to discuss some of the changes is Catherine Creer, an advocate and a legal researcher at the Helen Suzman Foundation. Catherine, good evening, and thank you so much for your time then tonight. What in particular are you concerned about?
Well, the Electoral Laws Amendment Bill has two clauses in particular that give civil society cause for great concern. That's clauses 14 and 21, which seek to empower the Independent Electoral Commission to prescribe a different voting method to that which has already been prescribed in our Electoral Act and in the Municipal Electoral Act. Now, our current system provides for a traditional voting method. That's one that involves a ballot, a secret voting booth, and a sealed box. This opens the door for the IEC to prescribe an entirely new voting method, including an electronic voting method.
Why would that necessarily be a problem? So why would electronic voting, for instance, be something that you don't advocate for?
So electronic voting is certainly not a problem in and of itself. It is consistent, or can at least be consistent, with the constitutional right to free and fair elections. However, electronic voting is far more susceptible to electoral fraud than the traditional voting method, which we have currently prescribed in our legislation. And this is for a number of reasons. Most importantly, electronic voting systems are far less transparent than traditional voting systems. This is because you don't have a paper trail, which we would ordinarily have, and you're not able to easily examine the various important steps in the electoral procedure without specialist expertise and knowledge, making it far more difficult for the public to understand, undermining public trust in elections and the perceived legitimacy of our elections. This requires special safeguards to be put in place if we are going to move to an electronic system. And that is not at all consistent with simply conferring the power on the Independent Electoral Commission to prescribe a new voting system without following the ordinary parliamentary procedures.
So effectively, are you saying if the IEC is given this much power to decide how people can vote and ultimately change that, there is no recourse that would be available to Parliament should it be found that the system they choose is flawed and would not benefit democracy in this country?
Well, there certainly is some recourse available. The first one would be to bring a constitutional challenge in court. And I think the bill as it currently is formulated, and if it is enacted with clauses 14 and 21, doesn't pass constitutional muster and could easily be set aside in a court of law. The second obvious recourse that is available to Parliament would be to amend the legislation again, to remove that power from the IEC or to prescribe a different voting method if the voting method prescribed by the IEC is found to be unacceptable. Just quickly, the reasons why I think the bill as it is currently formulated will not pass constitutional muster is because it seems to me to be an impermissible delegation of Parliament's lawmaking function for it to confer this power on an unelected entity, the Independent Electoral Commission. Parliament has a number of constitutional obligations when it acts as our lawmaking body, including facilitating public participation. And by simply delegating its lawmaking power to another entity, it successfully sidesteps its constitutional obligation to make sure that as members of the society and the electorate, our voices are heard on a potential new voting method, especially something as integral to our democracy as the way in which we vote. Another concern is that the Constitution itself requires our electoral system to be prescribed in legislation, and the Constitutional Court has made it very clear that the constitutional authority and duty to design the electoral system rests with Parliament, and that the details of our electoral system are a matter best left for Parliament. With this understanding, it seems to me that although Parliament can ordinarily delegate its lawmaking powers, the key details of our electoral system must be determined by Parliament in national legislation and cannot be delegated to another entity.
Of course, part of what that then might likely do is that we could see a delay then in the finalization of the amendment to the electoral bill. So if I hear you correctly, it won't be ready for perhaps the next national elections.
Well, certainly the electoral bill may proceed simply without clauses 14 and 21, which are the problematic clauses. It's open to the Portfolio Committee to abandon these clauses and proceed with the process for enacting the bill, which would make it ready for the next election. In any event, the proposed amendment in the clauses with which the HSF takes issue would not necessarily usher in an electronic voting system in time for our next elections. It simply confers the power on the IEC to do so if it should choose to, and it's not entirely clear if or when that would take place.
Catherine Creer, let's leave it there for tonight. Thank you for your time. She is an advocate and a legal researcher at the Helen Suzman Foundation.